There are some things that I suppose you can get, and by the economy model, there are some things that you probably want to avoid, things like parachutes, brain surgery, and I would say bankruptcy services as well. It's true that some cases are bread and butter vanilla Chapter 7s and there aren't any complications. But I regularly have people call up saying my bankruptcy case has just burst into flames. The trustee's taking all my stuff. I'm in big trouble. What can I do? My question then is, well, talk to your attorney. Well, I did, but my attorney doesn't do this kind of stuff and he's kind of new at it. Okay. Well, that's one of those things where not being too cheap and hiring somebody that really has the knowledge and skills avoids that kind of thing. And let me give you a couple of examples just to illustrate what can go wrong. And I've seen these, not in my cases, I'm pleased to report, but in cases of people who call me trying to get me to do repair work. And I used to do repair work in the past, but now I've decided against it because usually the amount of work that's necessary to do the repair is so much more than if you'd done it correctly that I'm going to charge more, and then the debtor doesn't want to pay because, well, I already paid the cheap attorney. One common thing that comes up is a fraudulent transfer. Now, in the previous video, we talked a little bit about fraudulent transfer. Let me bring out the salient points of fraudulent transfer law. Fraudulent transfer law has been around since ancient Rome. So this is a very well-developed area of law. In the United States, we have two basic working definitions of a fraudulent transfer. The first is you transfer an asset with the intent to hinder, delay, or defraud your creditors. There is the problem of the word intent. How do you know what another person intends? Since we can't read people's minds, the law has a second independent definition. A transfer is fraudulent with respect to a creditor if it's done without getting a reasonably equivalent value in exchange for the transfer. Now, what I have seen on occasion is a person transfers the home to the son, let's say, or to the daughter, and then files the bankruptcy. Well, you want to be very careful about that because that is a fraudulent transfer since the child didn't necessarily pay a reasonably equivalent value in exchange for the transfer. You go into the bankruptcy case, the trustee can undo that transfer, avoid the transfer, and seize the asset. So your clever move really backfired on you. On top of that, in a situation like that, you need to wait. Fraudulent transfers have a look-back period that is dependent on which statute a trustee appeals to. If the trustee appeals to the bankruptcy statute in Section 548 of the Bankruptcy Code, measured from the day the debtor files the petition, the trustee can go back 2 years. But the Bankruptcy Code permits the trustee to piggyback on non-bankruptcy law. Well, the second stop in that train is the California, what used to be called the California Uniform Fraudulent Transfer Act. Now it's called the Avoidable Transfers Act, Uniform. And that has a look-back period of 4 years measured from the day the trustee files the complaint to do the avoidance action, plus additional time up to 7 years if the transfer couldn't have been readily discovered. And if the debtor has a debt to the IRS, the trustee can piggyback on the IRS's fraudulent transfer statute and go 10 years. So a good experienced attorney is going to spot that and say, whoa, wait a minute, this is not a good idea. If you file this bankruptcy case, it's going to blow up in your face. Now there's not only the avoidance action that the trustee can do if you don't wait long enough, but if you have done a fraudulent transfer within the 12 months prior to filing the petition, you are ineligible for a Chapter 7 discharge. So yet another reason why it's a good idea to get an experienced attorney rather than El Cheapo mill attorney, because that experienced attorney is going to scope that out and see, oh, we've got a problem there. The second thing that can come up, I had this come up very recently, I'm pleased to report that my clients came to me rather than to an inexperienced attorney. The husband had an inherited IRA. That is an individual retirement account. Now, one of the things we include in a set of bankruptcy papers under any chapter, and in this case, it was going to be a Chapter 7, is a complete listing of everything the debtor has. And all of those assets get divided into two categories, exempt and non-exempt. The debtor keeps the exempt stuff. The non-exempt stuff goes to the Chapter 7 trustee for liquidation. We determine whether something's exempt or non-exempt by appealing to one of two exemption tables, one for homeowners with equity, the other for everybody else. In this case, they were in the everybody else category because they were renters, but this would have applied in the homeowners table as well. One of the categories for exempting assets is retirement funds, and there's no dollar limit in exempting those retirement funds. You can exempt pension money as long as it stays in the plan, 401ks, 403bs, IRAs. Now the question arises, suppose it's an inherited IRA. Dad died, he had this IRA, I got it in the will. Well, it's a retirement plan, isn't it? Well, the U.S. Supreme Court says no. It was a retirement plan for Dad, but now the heir doesn't get it as a retirement plan. It's just money. And so if these people had filed their Chapter 7, what would have happened? The Chapter 7 trustee would have grabbed that inherited IRA, and that money would have been gone. It would have just been tossed to the wind. So if they had gone with an inexperienced attorney who didn't probe and poke around and also know Supreme Court bankruptcy jurisprudence, and, well, I'm in the Ninth Circuit bankruptcy jurisprudence, then they might have said, oh, well, it's an IRA, it's exempt, fine, no problem. But if you are willing to spend a little more for the level of skill and knowledge you get from a board-certified bankruptcy law specialist, which I am, certified by the California State Bar Board of Specialization, then you're going to get a much higher level of skill and knowledge. Well, think about it in a different context. If you're going in for brain surgery and you want the guy who says, well, I've never done this before, but let's give it a try. No, you want the guy who's got all kinds of experience, the certification, he's done this surgery 50 times. He really knows his stuff. That's the guy you want. Or the guy who goes to, he's going to do skydiving. And he decides he's going to go with a budget outfit. Well, the guy who folded the parachute, yeah, I don't really know what I'm doing on this, but I figure just, isn't it like folding a sheet or a pillowcase? And then that didn't work out. So generally you get what you pay for. Don't cheap out when it comes to legal services because it will come back to haunt you. And some of those things that you do, there is no repairing them. Things like filing with the inherited IRA. Once you file, there's no undoing that. Or you file with a fraudulent transfer. I remember being at a hearing some years ago where a woman was the debtor and she had sold her house to her parents for $10. She said it was legal. Yep, it was certainly legal. But when you have creditors, it has implications. So you want to get a competent attorney.